Well, hello, everyone. I'm still Martha Minow, and it is my great delight to welcome you to a panel discussion in celebration of Justice Stephen Breyer's 20th year on the Supreme Court. And as law professors, we have not a lot to give, except for our ideas and our opinions. And therefore, rather than give Justice Breyer a dozen roses or a dozen race cars, we're giving him a dozen comments on his opinions. And indeed, members of the faculty have been hard at work on this for some time, and there was some competition over, there were so many good cases to write about. But nonetheless, we are going to proceed with a set of comments about some of his wonderful opinions. Some of them are majority opinions, some of them are dissenting opinions. And we've invited Justice Breyer to also give his own comments. If he does not want to comment on any given case, he is allowed. But we will then open it up for a more general conversation with the panel and with the assembled crowd. I was trying to think what else besides roses might come in a dozen, and it did strike me that a jury might be also coming in that form. And I think that the jury's view is, you are stupendous. But let's hear directly from the panel. So I've asked John Manning to start us off. Would you do that?
I'd be happy to. Thank you, Dean Minow. Justice Breyer, thank you very much for being here. Congratulations on 20 years of distinguished service on the court. So what I decided to write about was Justice Breyer's position on deference, and I'd like to start just by, I'm going to be very brief. So over the past quarter century or so, the court has become more textualist in its approach, and Justice Breyer during that time has remained a steadfast adherent of the legal process approach to interpretation. The principles are straightforward. The text of the law matters, but law is enacted for a purpose, and we should therefore read it purposively. More than that, we should read the law in a constructive light. We should assume where possible that the legislature was reasonable and sensible, and not the opposite. Doing so makes the law better, and according to Justice Breyer, it also makes democracy work better. Voters, the justice says, hold their representatives accountable for their overall policies and not for their placement of semicolons. The current court is more apt to pay attention to the semicolons. And why is that? Legislation, they say, is about compromise, and the words of the statute best reflect the compromises that were struck. And many people have pronounced the legal process school as on the ropes or worse. But I think as the question of deference to agency interpretations of law, what I'll use as shorthand, the Chevron question, shows that the legal process school is alive and well. And I think that's largely a function of Justice Breyer's influence. So the key to deference is delegation, right? Why would a court accept the agency's view of what a statute means? The only reason is because Congress tells them to. Congress tells the courts to accept what the agencies say within a range of reasonableness. But the court almost never says directly what it wants but Congress almost never says directly what it wants the courts to do. So the court has to make an estimate, has to guess what Congress would want if it addressed the question. Until 1984, the court used an all things considered approach. It would think about things like, does this question require expertise? Was the agency one of the drafters of the law? And all the factors that a reasonable person would want to know in deciding whether Congress would want to defer. In 1984, kind of out of the blue actually, the court switched to a categorical approach. The Chevron case said, if an organic act, if an agency statute has ambiguity, we will presume that deference was intended. And now, at the turn of this century, the court has moved back in the direction of the all things considered approach. It has a couple of categories where deference is presumed, but it has said that it's open to considering whether other considerations suggest Congress intended for the reviewing courts to defer to agency interpretations of law. So this alone, the Meade Doctrine alone, is an important victory for Justice Breyer. He's been saying all along that it makes sense to have a textured approach, to reject a one-size-fits-all approach to deference, because the administrative state is vast and varied. There are lots of different agencies, lots of different schemes. It's bizarre to think that Congress would want one approach for all of those schemes. And in the absence of a clear signal from Congress, he says that we should assume that Congress wants the courts to do something sensible with respect to each case, with respect to each scheme. So I have to say, I can see the virtues in both the Chevron approach, the categorical approach, and in Meade. A clear rule like the Chevron approach, the Chevron test itself, gives Congress a baseline against which to act, a clear baseline against which to act. In fact, a recent article by Abby Gluck and one of Justice Breyer's law clerks, Lisa Bressman, suggests that legislative aides may actually be able to wrap their minds around a rule as simple as Chevron, but not around more complex rules like Meade. On the other hand, I can also see the virtue in a more tailored approach. To me, both positions seem like positions that a reasonable legislator could love. And that brings me to the larger point. When Congress hasn't clearly resolved what it wants, as in the case of deference, courts may have no choice but to decide what they think is reasonable and to attribute it to Congress as a whole. In those cases, the legal process approach may be just plain inevitable. And even more than the basic choice between Chevron and Meade itself, that is a triumph for Justice Breyer. Congratulations on 20 years, Justice Breyer.
Thank you. So, Justice Breyer, do you want to make a comment?
First I want to thank people for doing this and actually reading these opinions with care. And, I was afraid good opinions, well, that might be like one of these famous small, thin volumes, like Spiro Agnew's Good Government Efforts, or whatever it was, or Franklin Pierce's joke book. I mean, you've obviously put thought into this, and it's very helpful. And what I think generally about is that we, you, are all going to be part of a profession, the students, where there are three parts, and they interact. And the judges judge. And then when they write an opinion, you don't know. It goes out into thin air. And who knows? Maybe like Mount Everest. But the law professors read it, and they do think about it. And they put it in a context. And they'll say, well, we like this part over here, but we're so a little uncertain about that part, and here's why. And then you get an article or a commentary, and the students will read it, and other law professors will, and practitioners will. So it'll influence the practitioners. And then it comes back to us through their eyes, if they think it helps them, and somebody will think it. So therefore there's this continuous process which is supposed to work in the direction of at least staying constant or maybe even getting better. And so it's very nice to see this, and I appreciate that effort. And on the particular thing, yeah, I agree with him. Who would have thought? John Stevens meant Chevron. If you're an ad law buff, when I talk about ad law, which a lot of these are about, I say, this is fantastically interesting, and it will be interesting. You have about 6 people who love ad law, and I'm one of them, and so are a few of the teachers here. It's a good subject. And all I'll say in favor of ad law, and I do think on the particular thing, I think that John Stevens meant Chevron to be a rule of thumb, not some kind of bright line thing. And then he writes later, in that immigration thing, Cardozo-Fonseca, he says, using ordinary canons of statutory interpretation, is the law clear? And if it isn't, is the agency reasonable? That's a good rule of thumb. It doesn't always work. I can say, fine, it doesn't always work. Where it doesn't work, don't use it. There we are. And what is really at stake in these things, what I think is at stake is this, that when I'll talk to foreign judges, very often they want to know what kind of constitution we have, what can we do, and that's a long story. But one part of that story, I say, I hope you also have an Administrative Procedure Act. And that isn't as parochial as it sounds. Because at the heart of every Administrative Procedure Act that I know of, whether it's in Europe or it's in China, wherever it is, still, I don't know what they have in China, but the idea is it is contrary to the rule of law to have arbitrary action. Now that's important. What is the arbitrary? The arbitrary is the unreasonable, the biased, it could even be the dictatorial, the tyrannical. Go look it up in the dictionary. And a rule of law, if it's supposed to stop anything, is supposed to stop that. And therefore, where you have ad law trying to stop the arbitrary by those in power in 1,000 different ways, that's a great thing for a nation to have. So it may sound a little technical, Cardozo, Fonseca, Chevron, Meade, etc., but underneath is something that isn't technical, and it's people trying in slightly different ways to have a method for judges and for lawyers to get a hold of the arbitrary and say no. All right, that I think is basically what's going on, and you have one aspect of that debate.
I should say that Charles Fried, who's going to be invited to comment at the end, you can comment at any time if you want to as well. Yes?
Well, it's my comment follows on John's really excellent essay, and in defense of the Breyer view of statutes. After all, if you look at the Constitution, not just one or two, but most justices, maybe all justices, take the Breyer view of the Constitution. That what you do is you look at it and you try to make it the best document it could be. You would never get some of the doctrines we have, whether it's the First Amendment or Lawrence or many other things, if the justices were not doing that with the Constitution. And then let's skip down from the Constitution to contracts. How are judges supposed to interpret contracts? They're supposed to interpret them exactly as Justice Breyer said. Judges are supposed to interpret statutes, that the parties to the contract are trying to make sense out of something, that they have a purpose, that there's something reasonable here, and that's what you're trying to do. Well, would it not be odd if at the level of contracts you adopt that method, at the level of the Constitution you do, but in between with statutes you do not? Why?
Thank you. So, in the spirit of reasonableness, let's turn to Professor Rakoff.
So what I'm going to talk about is simply an annotation of this statement you just heard, that the rule of law is the opponent of arbitrary official action. The case I'm going to talk about is actually a First Circuit case, because we shouldn't lose track of the fact that although the justice has been on the Supreme Court for 20 years, for 14 years before that he was on the First Circuit Court of Appeals. And the case I'm going to talk about, although written in 1989, is one that I still teach. It's called Shaw's Supermarkets versus the National Labor Relations Board. And the facts are actually very simple. The vice president of Shaw's Supermarket, which is a chain in New England, said to the workers as they were about to vote whether they were going to join a union or not, if we have negotiations with the union, we're going to start at what's legally required, the minimum wage and workman's comp, and we'll see what happens from there. And the question of the case is whether this statement, known as a bargaining from scratch statement, constituted a threat of reprisal to the workers, that if they joined the union, the company was suddenly going to get very nasty. And if so, was that coercive and in contradiction of their rights under the National Labor Relations Act? The opinion that Judge Breyer wrote concedes that the board would have the authority to make that statement a violation of the act. But it then goes on to review paragraph by paragraph 10 or 12 cases that the board had decided over the last several years where companies had used these bargaining from scratch statements. And it shows that in those cases, when the company official had only used the bargaining from scratch statement and hadn't committed some other coercive act, that the board had found that that was okay. Whereas in this case, on essentially the same facts, the board had overturned the election that the company had won and had ordered a new election. So the court remands to the board. All right? Now, if you think about it, the court's not remanding to the board because what the board did was outside the board's authority, because it's conceded that if the board had overturned its precedents, it could have reached that result. What was wrong with what the board did was that, to use the justice's words, it acted arbitrarily, that it acted without regard to its own precedents, that it acted in a way different from the way it had acted with regard to other similar cases that had recently come before it and had not explained why it was acting differently. If you press that a little bit more, when he says the rule of law is the opponent of arbitrary action, what he's really saying in that case is the rule of law that is established by the partnership of the judges and the board. The primary responsibility for acting in a law-like fashion belonged to the board. It was the board's job to look at its own precedents. It was the board's job to figure out whether they should be overruled or not. And that's why the case was being sent back to the board for the board to do its job. It was the judge's job to create the conditions under which it made sense for the board to follow the rule of law. So, sort of now taking this point at a slightly higher level of abstraction, it seems to me that this way of viewing administrative law, of which he and I are both devotees, viewing administrative law is based on two, I don't know whether to call them philosophical assumptions or character traits or biographical statements on his part. One is that administrative action, and the statutes that set up administrative action also, are based on reasons. Undoubtedly, they represent an act of will, but they are not simply acts of will. They are acts of will that are based on purposes, based on reasons. And secondly, that the kinds of reasons that administrative action is based on can be understood by the generalists of the legal order, the judges. Now, there's a broad body of administrative law scholarship that challenges each of those propositions. There's a body of scholarship which says statutes in administrative action are fundamentally willful acts, that you should not be looking for purposes. All you should be looking for is the political sciences balance of the vector forces in the field of forces which created the act. And there's a broad body of scholarship which says that the expertise that administrators use is beyond the ken of the generalist judge, that it is the expert's expertise, and the only thing that the judges can do is see whether it went out some outside boundaries or not, but they cannot actually penetrate and understand it. Judge Breyer, and in several Supreme Court opinions, Justice Breyer is clearly opposed to both of those propositions. He believes that agencies do act on reasons, and judges can understand those reasons, and that therefore that the hope that political will and the rule of law can go together rather than just simply be opponents of each other is a possible hope. He stands in opposition to Yates's statement that the center will not hold. His view is the center can hold. And that's my rose.
Excellent. So one thing that's interesting to think about this approach is if you assume that there's no reason going on in the government, what does that invite the government to do? Justice Breyer, would you like to comment?
Right, no, I have no comment, that's right, but don't, they keep saying I do this or I do that. I don't make up these things, you know, and I never did. And if you want to, as Todd knows, and certainly Cass and the others, I mean, people say, if you want to know what a Supreme Court justice bases at bottom, in broad philosophical terms, his decisions on, look at who his law professors were 30, 40 years before. And that's true. So you will come out of this law school with your views of law very much shaped by the teachers you had. And my teachers were Al Sachs and legal process, correct. And I have never seen anything wrong with that. And my ad law teacher was Louis Jaffe. And you say, where do these come from? And Louis, there is a common law of administrative law, which there is. Don't change your mind without explanation, agency. Why? Because you said why. It's arbitrary. And Louis had all that stuff, and Cass has picked it up. I've picked it up, and there we are. We're sort of going further with it, maybe, and or maybe not. But that's an important point to keep in mind. And the other thing, I'm glad people are reading these opinions. Of course, it's satisfying for me, because I'll tell you, by the time you have 13 years teaching at the Harvard Law School straight out, plus 14 years as a Court of Appeals judge, plus going on 20 for the Supreme Court, most of the things you remember with perfect clarity never really happened.
So Professor Glenn Cohen is going to take us in another direction.
So my essay begins with a comparison anybody who's ever read a Justice Breyer opinion, I'm sure all of you in this room have no doubt thought about, which is the comparison between Justice Breyer and Tim Gunn from Project One Way on reality TV, right? So this is not merely a statement of Justice Breyer's admittedly excellent fashion sense, but if you recall, Tim Gunn's slogan is, make it work, right? Make it work, right? If ever there was a slogan for Justice Breyer, especially in the area I work in the health law area, and I'll talk about patent law, it's make it work. In his confirmation hearing, Justice Breyer said, I believe the law must work for the people. The vast array of constitution, statute, rules, regulations, practice, procedure, that huge, vast web has a single basic purpose. That purpose is to help many different individuals who make up America from so many different backgrounds and circumstances with so many different needs and hopes, right? To make it work. Sometimes this becomes almost a bit amusing if you listen to Justice Breyer's questions during oral argument. My favorite example was from the Norfolk case, a case about the occupational injuries of a railroad worker who connected one rail car to another. And during the oral argument, Justice Breyer let the railroad's advocate know that, quote, my law clerk found a device in the Car and Locomotive Cyclopedia for 1974 that could make the task safer, and also noted that they had 4 pictures in the encyclopedia, right? Just something helpful to know if you're running a railroad, maybe tell the other people who are working there. Well, so this pragmatism, this desire to make things work that is at the heart of, I think, Justice Breyer's jurisprudence really comes evident in his jurisprudence on patent law, where I think most those of us who watch that area of law are excited when he gets to be the one to write the opinion. I'm going to talk about one opinion, I talk about more in the essay, the LabCorp opinion, LabCorp v. Metabolite, where Justice Breyer, joined by Souter and Stevens, takes the unusual step of dissenting from the court's dismissal of cert. In so doing, he sets out the legal theory that's going to guide the court in subsequent jurisprudence and really build the glide path to Myriad, a case that was just decided last term on gene patenting. So what is the case about? It's about homocysteine. Doesn't sound all that interesting, but it is, right? So people have known for at least half a century that high homocysteine levels are associated with serious health problems. But it turns out to be very difficult to measure them. Well, along comes this patent holder who determines that this level of homocysteine is a sign of folic acid and vitamin B12 deficiency. And from that correlation, we can tell if your homocysteine is too high, too low, and what you should do about it. And the question in the case centers on Claim 13 in the patent. And that is basically that these patent holders, quote from the opinion, created a protected monopoly over the process of correlating test results and potential vitamin deficiencies. Should you be able to have a patent on that correlation? And in explaining why the court initially grants cert and then it dismisses as improvidently granted, in explaining why he finds it wrong to dismiss that way, Justice Breyer, it's vintage Breyer. It's practical, It's not interested in adversarialism or wasting time. It takes note of when expertise can be useful. And unlike many of the other justices, I might say, it's extremely respectful of his colleagues on the other side. So this is what he writes. Notice he uses a very impersonal tone. Quote, "I can find no good practical reason for refusing to decide this case. The relevant issues have been fully briefed and argued by the parties, the government, and 20 amici. The record is comprehensive, allowing us to learn the precise nature of the patent claim, to consider the commercial and medical context, and to become familiar with the arguments made in all courts. Neither the factual record nor the briefing suffers from any significant gap. No party has identified any prejudice, and there's no indication that LabCorp's failure to cite Section 101, that is the section pertaining to patentable subject matter, reflected unfair gamesmanship. Of course, further consideration by the Federal Circuit, that was maybe a little bit of a Freudian slip there, the Federal Circuit might help us reach a better decision. Lower court consideration almost always helps, but the thoroughness of the briefing leads me to conclude that the extra time, cost, uncertainty would engender are not worth the potential benefit." And then he says that there's a real cost to not deciding the case. He writes, "To fail to do so threatens to leave the medical profession subject to the restrictions imposed by the individual patent and others of its kind. Those restrictions may inhibit doctors from using their best medical judgment. It may force doctors to spend unnecessary time and energy to enter into license agreements. It may divert resources from the medical task of healthcare to the legal task of searching patent files for similar simple correlations. They may raise the cost of healthcare while inhibiting its effective delivery." Again, the notion of the system has a purpose, and the purpose of a judge or a justice is to help the system work. And he writes, and again, it's hard to imagine any other justice writing this next line. "Even if the analysis we have offered on the merits is wrong, however," not many justices, I think, would write that in an opinion, "it still would be valuable to decide this case. Our doing so would help diminish legal uncertainty in the area, affecting a substantial number of patent claims. In either event, a decision from this generalist court could contribute to the important ongoing debate among both specialists and generalists as to whether the patent system is currently administered and enforced adequately reflects the careful balance that the federal patent law embodies." But far from actually getting it wrong, in my opinion, Justice Breyer gets it completely right. He says, wrestling with a fundamental question, what is a fundamental law of nature? He says in this beautifully precise paragraph, I'm going to read the paragraph, I'm sorry to go on a little bit about this, but I think if you wanted to understand how patent law works and the big debates from an intellectual perspective in patent law, this would be one of the best places to start. He says, "The justification for the principle does not lie in any claim that laws of nature are obvious, or that their discovery is easy, or that they're not useful. To the contrary, research into such matters may be costly and time-consuming. Monetary incentives may matter, and the fruits of those incentives and the research may prove of great benefit to the human race. Rather, the reason for this exclusion is that sometimes too much patent protection can impede rather than, quote, promote the progress of science and the useful arts," unquote, the constitutional text. He says the problem arises from the fact that patents do not only encourage research by providing monetary incentives for inventions, sometimes their presence can discourage research by impeding the free exchange of information. For example, by forcing researchers to avoid the use of potentially patented ideas, by leading them to conduct costly and time-consuming searches of existing or pending patents, by requiring complex licensing arrangements. He says that patent law seeks to avoid the dangers of overprotection just as surely as it seeks to avoid the diminished incentive to invest in that underprotection can threaten. One way in which patent law seeks to sail between these opposing and risky shoals is through rules that bring certain types of invention and discovery within the scope of patentability while excluding others. And when he gets to this actual claim, the one in front of us, he writes, and again, it's beautifully understated, it's kind of amusing, I think. Claims 13's process instructs the user to 1, obtain test results, and 2, think about them. Why should it matter if the test results themselves were obtained through an unpatented procedure that involved transformation of blood? Claim 13 is indifferent to that fact, for it tells the user to use any test at all. Indeed, to use virtually any natural phenomenon for virtually any useful purpose could well involve the use of empirical information obtained through unpatented means that might have involved transforming matter. So he finds it unpatentable. Well, you might say, what's the significance of the opinion? And I'm sorry, Justice Breyer, in a practical sense, Not really much, right? It's a dissent from the dismissal of certiorari, as improvidently granted. It's not binding authority anywhere. It could have found its way into the dustbin of Supreme Court history. But those of us who write and think about these areas love this opinion, and why? Well, first of all, it is a perfect description of the patent dilemma that can be understood by the general public, something that is also one of Justice Breyer's major goals as he announces in his work. Second, it nudges the Federal Circuit, now I'll say it this way rather than circus, although again, depending on where you stand on patentability, you might have different views about the matter, into a course correction that they kind of make, not all the way there. But finally, I think most importantly, is it creates a glide path for the court that led to Prometheus, an extremely important decision also decided by Justice Breyer on patentability, and most recently, the Myriad decision, two of the most important decisions patent law has seen for 50 years. So Justice Breyer, it feels a little disingenuous to give you as a rose back so many of your own words, but I hope you will at least enjoy them and take them with you.
Probably don't know, because it just has to do with my own mental process, and it shows something about the value of an adversary process. All right, we got Prometheus, which is the next case. Now the lawyers, I'm glad I wrote that dissent. The lawyers have read it, you know, for both sides. So the ones that are defending the patent don't think I'm their best friend. But they take me on and say, and they make a point, which is a good point. And they say, this isn't right for the following reason. And to really simplify, but it's basically, look, Archimedes discovers whatever the principle of flotation is, you know, things float. I can't remember, that was in high school. And you have displaces a certain amount of water, and if it's this amount, anyway, he had the principle. And he invented it. Archimedes, he discovers it's a law of nature. Can he go and patent that? No. And the patent people say, that's right. He can't go and patent that. But he can patent the application of that. And so if it's the application of a law of nature, he can patent it. And indeed, if that weren't so, you wouldn't have any patents, or very few. Okay. So when is it an application? And when isn't it? And then that becomes the issue in Prometheus. And it's not so easy an issue, because Archimedes goes to the boat builders and he says, I'm not patenting my law of flotation. I'm just patenting it for the purpose of building boats. Einstein goes to the linear accelerator people. He says, I agree, E equals mc squared cannot be patented, but I'm just patenting it for the purpose of building linear accelerators. Well, you know, if you did that, you'd make a joke of the law. So how do you decide it? And when is it of application, when isn't it? Now that becomes tough, and you have to go into that. So do I answer that question? I try, but for all time, absolutely not. And indeed, then that leaves everyone with a lot to do, including the Federal Circuit, in future cases, to try to figure that one out. Now, would I have seen that without having written the first and then they addressed? No. So there's a plus there for the adversary process.
I also wonder if there's a plus there for Dr. Joanna Breyer in discussing science with you throughout the years. And psychology, too. So we turn now to Professor Martha Field, who takes us yet in another direction.
I wrote about Holder versus Humanitarian Law Project, which is usually referred to as HLP. It's a case in which Justice Breyer wrote the sole dissenting opinion. It was joined by Justices Ginsburg and Sotomayor. And the case concerned the government's prohibition of material support of terrorism and an application of that to peaceful activities of human rights organizations. So the plaintiffs were human rights organizations and individuals who had taught and wished to continue to teach negotiation skills and some international law to two organizations that the Secretary of State had designated foreign terrorist organizations. One was the PKK, representing the Kurds in Turkey, and another was the LTTE, the Tamil Tigers of Sri Lanka. The plaintiffs claimed that their activities were protected by the First Amendment. They were speech-related activities, and they didn't in any way contribute to any illegal activities that the organizations might engage in. Indeed, instead, they aimed to teach the organizations to use peaceful instead of violent means. But the Chief Justice, writing for 6 justices, ruled against the plaintiffs. He claimed that a rigorous scrutiny was required because it was a content-based suppression of speech. But then he didn't really apply very rigorous scrutiny. It was far less rigorous than the scrutiny that had been applied just 5 months before by 5 of those 6 justices in the Citizens United case. It was far less vigorous than the scrutiny in other national security cases, like the Pentagon Papers case. But what the Chief Justice said is that, well, it's really difficult to second-guess the government on foreign affairs and national security, so we really don't have any choice but to defer to the government. So it didn't amount in practice to rigorous scrutiny at all. Now, there were other cases that had been decided before by the Supreme Court that had culminated in a decision in 1969 in a case called Brandenburg versus Ohio, in which the court set forth a modern clear and present danger test, under which even speech that advocated illegal activity could not be punished unless the speaker had a specific intent to bring about a grave harm and the harm was imminent. So the Chief Justice didn't explain why that Brandenburg line of cases wasn't applicable in this case. He did say that whatever test he was applying this time would be applied only to foreign organizations and not to domestic ones. So that seemed to be the line dividing HLP from the clear and present danger cases. It's difficult to accept that dividing line, though, because it's very difficult to tell the difference between what he's going to consider foreign and what he's going to consider domestic. For example, the Edward Snowden case, the Patrick Manning case, are these, would he consider these foreign or domestic? Communist Party cases had been considered domestic, but they might have been considered foreign under this same analysis. Indeed, in this case, it was American human rights workers who had brought the case, and it was their speech that was being interfered with. So the problem really was that the recipients of the speech were foreign. It seems a somewhat tenuous line on which to draw a big division between what test you're going to apply, whether a strict one or a very loose one. So the result was creation of great uncertainty about when the established stricter standard of Brandenburg v. Ohio would be applied and when the new HLP defer to the government standard would be applied. And it made uncertain an area of the First Amendment that had been clear for really more than 40 years. So Justice Breyer dissented. First of all, he recognized the First Amendment implications of what the court had done, which the court had really given rather short shrift to. He pointed out it was political speech, critical of the U.S. government, that was involved, and this is the kind of speech that is most central to First Amendment in most analyses. He discussed the grand policies of the First Amendment, but he also skewered the court's argument detail by detail and suggested a standard of his own. First, he criticized the court's deference to a legislative executive decision that had never been made. He pointed out that no decision maker had ever found that the activities of the plaintiffs would cause danger to the United States. The particularized fact-based decision-making that is characteristic of the First Amendment simply hadn't happened here. So there was it was not a good case for deference to the other branches. He then criticized the court's argument that the plaintiffs' activities would lend legitimacy to the designated foreign terrorist organizations. That was one of the justifications that the court had put forward for the law. But lending legitimacy to another is is central to free speech. Often when one talks, one is to lend legitimacy to someone or to some idea, or to take legitimacy from them. That's the kind of decision that an individual is to make, and not the government. And Justice Breyer makes clear that it would dismantle the whole First Amendment if the government were to take this decision upon itself. He then shows in detail that the help that the plaintiffs were giving, teaching negotiation skills, teaching international law, teaching how to petition the United Nations, were not skills that could directly contribute to any terrorist work. The court had said that all types of material support were fungible. Justice Breyer looked a little bit more carefully. He said teaching some things might contribute to, might be able to be used to contribute to terrorism. For example, teaching people how to use weapons, even teaching people computer skills. But the plaintiffs' desired activities of teaching negotiation really couldn't contribute to terrorism, and therefore they should not have been deemed by the court to be fungible with other forms of support. And finally, Justice Breyer also sought to tighten up the intent requirement. The material support statute had required that to violate it, one only had to know that the organization had been designated a foreign terrorist organization. Justice Breyer's approach was much more consistent with earlier First Amendment cases. He would not have allowed punishment for material support by speech unless the actor knows that his action would lead to imminent grave danger. The knowledge requirement couldn't be met in this case because the workers aimed to encourage peace and not to encourage violence. Finally, Chief Justice, excuse me, I just almost gave you a promotion. Finally, Justice Breyer dealt with the Chief Justice's argument that punishing plaintiffs' proposed speech was not drastic because only speech that was coordinated with the terrorist organization or directed by the terrorist organization was prohibited. Justice Breyer pointed out that association is protected as well as speech, and that prior cases dealing with Communist Party membership, for example, had not allowed punishment of Communist Party membership unless the individual punished had a specific intent to further the illegal goals of the organization. So he convincingly demonstrated that the court did not improve upon its case by punishing association along with speech. So the difficulty of holding to our constitutional protections when facing current dangers and perceptions is well documented and is apparent in cases, maybe cases like Korematsu that we were discussing earlier. But in this opinion, Justice Breyer showed the courage to hold fast to constitutional tradition and would not allow speculative fears to trump peaceful free speech. I guess I would have preferred if the result could have been reached as a simple and easy application of the established Brandenburg test. And I think the court should have explained why Brandenburg didn't apply rather than ignoring the decision and leaving the law in confusion. The Brandenburg test would have automatically protected the plaintiffs. Justice Breyer's was the only opinion that noticed the absence of Brandenburg analysis. He didn't argue that Brandenburg was applicable. He didn't apply it in this case. But the criteria he came up with in applying his own test brought the situation much closer to the Brandenburg requirements, much closer than the court's test did. He approached the case as a general strict scrutiny case because it was a prohibition aimed at content of speech. And interestingly, he showed that the same or similar requirements would prevail if it was analyzed in that way as if it was analyzed under the more categorical Brandenburg approach. That is, a grave harm is required, more than a tenuous connection between the prohibited speech and the projected harm, and a strict mens rea requirement before the speaker can be punished. So these requirements do bear a strong resemblance to the Brandenburg rule itself, and I think they support the view that the HLP cases and the Brandenburg cases should come together, should be treated the same way, rather than having drastically different rules apply depending upon whether we characterize the recipients of American speech as foreign or as domestic. So I thank you for your very good analysis. I thank you also for writing opinions without footnotes, which gave me which of course makes them much more accessible, and which also gave me an excuse not to have any footnotes in my essay here, and it made it a great pleasure to write. Thank you.
Great. Do you
Can I
want?
say one word about the First Amendment? What is amazing to me, which Larry knows, you know, everybody, really, there is no First Amendment law to speak of before 1920. And so, but we've had about close to 90 some odd years, and you would have thought by now people would have settled down and figured out this thing, and they haven't. Actually, you find case books on it, and so here we are, cases come up. Now, I'm sure in the particular, I'm moved by the fact that not very long before, I know is going to happen, I can't remember the exact order, but the court is going to say that when drug companies in Vermont get information from a pharmacist about what prescription people have, the doctor has prescribed, so that they can use that information to send salesmen to the doctor to say, I know you're using drug X, why don't you use my drug Y, which does the same thing. And Vermont thought that that affected prices. It might, and it might not, I bet it might. And therefore they say you can't do that. That violates the First Amendment. What? There's something backwards here. All right, but you see, that's a reaction, something backwards here. We get cases, and you have a reaction, but you also know there's an overall framework, and I know perfectly well, which is a good thing for students and others that they go into law to start working on. I can't say, though I like to say, that we can use this idea, which is, I'm afraid, a foreign idea, or they use it more abroad, called proportionality. And you do a kind of balancing thing, which I've written enough about. I won't bore you with it at the moment. But that can't be the whole story, because there's also something called political speech. So if you want to look at this problem, look at the Medal of Honor case, Medal of Valor, whatever it is, and Justice Kennedy writes 14 categories. Well, I'm not going to accept that and put everything in boxes, because I don't like boxes in general, because I think life is too complicated. But particularly beware in the First Amendment area, because your boxes will come back and hit you with really counterintuitive decisions. At the same time, there must be some. And which? And when? And how do you apply them? And how can you put the two parts of this thing together? I don't really know. I'll have cases where I have to give better answers. And that's true of all of us. You see, the 9 of us have these cases that come up. And you read the answers after we've reached them, for better or for worse. But that isn't how it looks to the people who are the judges. We don't know exactly the answers when this comes up. And we're going to have to take the raw material and come to conclusions, and that has to be done in a finite period of time. You can't sit down and, time marches on. And that's the job of being a judge. All right, so that's one case which I tried to answer in a particular way, and there's a lot to still do in this area.
Professor Larry Tribe is going to talk about peekaboo.
Well, before I talk about peekaboo, I just wanted to say a word about Justice Breyer and the First Amendment. If it had been, of course, all figured out, many of us would be out of work. And it's true, you don't use a lot of footnotes, but the appendix in peekaboo is like 30 pages or something. So if you can't put it in a footnote, put it in an appendix. Another point about the First Amendment before I talk about peekaboo is that a lot of people treat Justice Breyer as not really a First Amendment advocate. The real one is Kennedy. He wrote Citizens United. He is on the ramparts in these commercial speech cases like Sorrell. But I do think, whatever theory one has of the First Amendment, the centrality of political speech shows that the dissent in Holder v. HLP makes up for any number of things that somebody might have thought was an error. All right. Anyway, I chose a fairly obscure case, aptly named peekaboo, more formally Free Enterprise Fund versus Public Company Accounting Oversight Board, PCAOB, hence Peekaboo, decided 3 years ago. There, Chief Justice Roberts, joined by the usual 4 conservatives, struck down the limits on the SEC's power to remove members of the Public Company Accounting Oversight Board, created in 2002 by Sarbanes-Oxley as Congress's somewhat lame response to a series of accounting debacles like Enron. The Oversight Board had the power, in the court's words, to govern every accounting firm, both foreign and domestic, that participates in auditing public companies under the securities laws. So it had a very broad mandate. And the supposed constitutional flaw in the structure that Congress created was what the court's majority called its double for-cause removal provisions, which supposedly insulated the members of the Oversight Board from removal without cause by the SEC, which itself was in turn allegedly, and you'll see in a minute why I say allegedly, insulated from presidential removal without cause. The majority opinion was a blend of arithmetic, anti-Russian aesthetics, and a yearning for a unitary executive that would function without a layered bureaucracy. The problem, according to the chief, was that 2 layers of protection exceed 1. Good enough. And if 2 are okay, then why not 3, 4, 5? Where do you draw the line? This double-layered scheme of what he called safely encasing the Oversight Board within a matryoshka doll, that's where the Russian comes in, of tenure protections, which sounds un-American on the face of it, foreign, to use Marty Field's term, thereby immunizing the board's members from presidential oversight, even as they exercised power in the people's name. And that was supposed to be fundamentally undemocratic. Justice Breyer wrote a brilliant dissent, one that I think displayed all, or at least most, of his characteristic strengths and priorities at the same time. Functionally and pragmatically, in the spirit of making it work, he showed that the insulation of the Oversight Board's members from removal without cause by the SEC would not really prevent the SEC from exercising effective control over the board's conduct, especially given what he demonstrated convincingly was the virtually absolute power that Sarbanes-Oxley gave the SEC over just about everything the board did, and the degree to which restraints on removal power have historically had very little to do with an agency's actual independence, which depends much more on a complex array of political and fiscal considerations. Roberts, writing for the majority, really had no effective reply, but he just commented that a procedure's utility in facilitating effective governance, making it work, as it were, couldn't save it, quote, if it is contrary to the Constitution, which is a perfectly question-begging formulation. This is the whole question, was whether this particular procedure was contrary to the Constitution. To underscore the chief's disagreement with the Breyer emphasis on workable reality and the chief's evident belief that, to quote Lily Tomlin, reality is overrated, Roberts said, I quote him, "One can have a government that functions without being ruled by functionaries," you know, the people who are being laid off during the government shutdown, "and a government that benefits from expertise without being ruled by experts," which led me to think, ouch, that Roberts really knows how to hurt a guy. Here we have Breyer interested in functionaries and experts rather than democracy. Chief Justice Roberts added with a flourish that Justice Breyer's approach would facilitate the growth of the executive bureaucracy, touching every aspect of our lives, but slipping from the executive's control and thus from that of the people, a concern that he said was absent from the dissent's paean to the administrative state. Sort of double ouch. But Justice Breyer got the better of the argument, I think, at every level. Formalistically, he showed that Roberts was gratuitously reading the federal laws creating the SEC so as to insulate its commissioners from presidential removal without cause. Now, I'd always thought that the SEC commissioners could not be removed without cause. but I had something to learn. That was a reading essential to the majority's holding, about 2 layers of insulation by for-cause removal provisions. But it turns out it was not supported by any statutory language or authoritative precedent. And as Justice Breyer pointed out, it was quite unusual, perhaps unprecedented, to interpret a law in such a way as to make it unconstitutional rather than the other way around, which is what the Chief Justice says is his normal practice. Functionally, Justice Breyer reminded the majority that sometimes human arrangements empower precisely because they constrain, recalling the perfectly apt legend of Ulysses, who tied himself to the mast so as safely to hear the siren's song. So even if the effect of the supposed double insulation of the Oversight Board, I say supposed because it wasn't doubly insulated, was to limit freewheeling presidential removal, that could well be a way of empowering rather than enfeebling the President of the United States. Justice Breyer demonstrated, too, with no rebuttal by Roberts, that insulation from political control, far from being some anomalous thing, was well settled as constitutional for bodies that adjudicate cases, which the dissent pointed out calmly, reasonably, was exactly what the accounting board was set up to do, something that Roberts left absolutely and startlingly unanswered. Now, the coolest thing about all these devastating Breyer replies to Roberts was that he was smart enough not to rub it in. Now, unlike what some other justices, whom I will leave unnamed, tend to do with a dagger once inserted, Justice Breyer does not twist the knife. He just lets it sink in so that readers can figure out for themselves what the majority's agenda really is. Now, I have to admit, see one possible flaw in your dissent, Justice Breyer. Having shown that formal removal provisions don't really determine an agency's independence and functional autonomy, he nonetheless complained that the majority's invalidation of the for-cause removal requirement with respect to the SEC's control over the board would effectively cripple the board's autonomy. Now, that sounds like a kind of contradiction. That is, if the presence or absence of for-cause removal isn't really the sine qua non of an agency's independence, why is Justice Breyer so worried that this will prevent the board really from working? But if the game had gone into overtime, I think Justice Breyer could have easily shown that there was no real contradiction at all. And I have in mind something that I believe, if I'm not mistaken, Mark Tushnet was going to talk about, the Ten Commandments cases. Am I wrong? Well, in the collection of essays, I think that that Michael Claremont, at least, talks about the cases involving the Ten Commandments. And in those cases, and you wonder what that has to do with peekaboo, in those cases, Justice Breyer was the only one in both majorities. That is, he wrote that you cannot put the Ten Commandments for the first time in some little courthouse in Rhode Island. But he also wrote that you shouldn't rip out the Ten Commandments, which have already been there for a long time in this big public plaza in Texas. Now, the connection between that and peekaboo may not be entirely obvious, but it's all about path dependence. That is, if something has been around for a long time, changing it may make a difference that installing a procedural device at the outset would not. And in particular, while the independence of an old agency like the SEC would remain secure even if we all came to recognize that Justice Breyer's research was right and that its members really could be removed by the president without cause, the SEC would still be independent. We have come to think of it that way. That's part of the culture. But the court's insistence on inserting a new power to remove without cause into the crib of a baby agency like peekaboo could well deal a fatal blow to that infant regulatory body. So it wasn't really an inconsistency. If you don't insist on putting everything in boxes, there's the Establishment Clause box and the Administrative Law box, but if you mix them up a little, you see some important connections. Well, I thought it was a totally brilliant dissent, one that ran circles around the Chief Justice while remaining respectful and diplomatic all the while. So, bravo, Justice Breyer.
I have nothing to add.
Okay, Professor Tushnet, we'll talk about the first amendment speech.
Right. I am going to continue with the discussion of First Amendment issues in Justice Breyer's opinions using a series of increasingly ugly formulations talking about doctrinalization, de-doctrinalization, and partial de-doctrinalization. So the taking off point of this is that from the 1960s on, free speech law became doctrinalized in the sense that the court created a structured set of categories and rules. The rules are triggered by the identification of one of a relatively small number of features that doctrine makes relevant, like is this a content-based regulation? The structure allows for the development of qualifications and exceptions, each itself triggered by the identification of another one of a relatively small number of features, like is this commercial speech or not? Now, doctrinalization has a lot of advantages in promoting clarity and providing guidance, but it also has a number of important disadvantages. The two that I talk about in my little contribution is instability. As cases arise, they present problems that seem not to fit well into the existing doctrinal categories, and judges feel some pressure to create new exceptions or qualifications. And then as those exceptions and qualifications develop, the doctrinalization, the doctrinal structure begins to degenerate. The advantages that you got out of this structured set of rules and categories begin to dissipate as the structure gets increasingly complex. And so one alternative that Justice Breyer has been, I think, attracted to is what I call a partial de-doctrinalization. The partial part I want to mention here, because I don't talk about it in detail in my contribution, but it is that he's not, as his discussion of Holder indicates, not an advocate of the full-scale de-doctrinalization, which I'll describe in more detail. There are domains, political speech of critical of government policy, where he wants a relatively structured doctrine like the Brandenburg test. There is then a question of where you draw the line between the doctrinalized part and the de-doctrinalized part, and that I think is something for us as scholars to think about. It's not the kind of thing that one expects judges to do in their ordinary work of deciding cases. So what do I mean by partial de-doctrinalization? Well, I want to give two examples. One from the violent video case, Brown against Entertainment Merchants Association, and the other from the Stolen Valor case, U.S. versus Alvarez. In the violent video case, Justice Breyer says that he's going to apply a strict form of First Amendment scrutiny, and then that form requires, and here he's quoting from a whole bunch of statute cases, and the internal quotation marks are signals that he's operating within a doctrinal structure. The statute has to be narrowly tailored to serve a compelling interest without there being a less restrictive alternative that would be at least as effective. Okay. Then he says he's not going to apply this standard mechanically. Rather, what he's going to do is evaluate the degree to which the statute injures speech-related interests, the nature of the potentially justifying compelling interests, the degree to which the statute furthers that interest, the nature and possible effectiveness of possible alternatives, and in light of this evaluation, whether overall the statute works speech-related harm out of proportion to the benefits that the statute seeks to provide. Okay, so that's the formulation in applying not mechanically, but applying a strict form of First Amendment scrutiny. In Alvarez, he says, I'm not going to rely on a strict categorical analysis. I'm going to do something that has sometimes been called intermediate scrutiny, proportionality review, sometimes an examination of fit. And I want to focus here that he does use the term intermediate scrutiny. So now, what is intermediate scrutiny? It involves examining speech-related harms, justifications, and potential alternatives. In particular, it takes account of the seriousness of the speech-related harm the provision will likely cause, the nature and importance of the provision's countervailing objectives, the extent to which the provision will tend to achieve those objectives, and whether there are other less restrictive ways of doing so. Now, notice that that formulation, which is in form of intermediate scrutiny, is not noticeably different from the formulation of the strict form of scrutiny in Brown. And so that seems to me a signal that Justice Breyer wants the law to move from a doctrinal structure to a balancing or all relevant considerations or proportionality approach. And de-doctrinalization may call for this kind of blurring of doctrinal lines. Now, I want to raise just one question about the partial de-doctrinalization, or how de-doctrinalization can be implemented. And I think there's an interesting contrast between the violent video case and the stolen valor case. When I look at the formulations of Justice Breyer's approach, it seems to me that many of the components call for an assessment of, we can call it social reality or empirical evidence. In the violent video case, Justice Breyer looked at a whole range of evidence about the effects of violent videos on children's behavior, and said it wasn't sure that this evidence was conclusive in showing that viewing violent videos caused kids to become violent, but it was certainly a reasonable thing for the California legislature to conclude that this kind of effect occurred. Okay. Now, in the Stolen Valor Act case, I think there are similar either empirical or social reality judgments being made about the extent to which false statements that you have received a military honor impairs the reputational value to people who actually have received those medals, and in the details of the case, the likelihood that such an impairment would occur. My question is whether Justice Breyer thought the Stolen Valor Act was unconstitutional because it failed to satisfy this intermediate scrutiny test he formulated. My question is whether, to the extent that that judgment rests on an evaluation of these likelihood issues and the degree of impairment of reputation attendant on obtaining a military honor, why not apply the same degree of deference to congressional judgment about those, I would say, empirical questions as he did with respect to the California legislature's empirical judgments? My own view is that the move to de-doctrinalization is a very important one, deserves to be encouraged because the doctrinalization has led to what in other work I have called pathological results. The Sorrells case, the Vermont drug case is one. I personally, obviously Justice Breyer doesn't think that the Stolen Valor Act case is another. So I think the move to away from doctrinalization is a good thing. I think there are two unresolved issues in the program of de-doctrinalization, which I now don't want to attribute as a program to Justice Breyer entirely. One is, as I've suggested, the sort of domain question of where are you going to preserve doctrinal approaches. And where are you going to do this proportionality or all things considered kind of approach? And the other is the proper role of deference to legislative judgment in the de-doctrinalized domain. My own view is that at least if that domain is properly defined, a very high degree of deference, I attribute this to Thayer in the tradition of constitutional theorizing, a strong presumption of constitutionality ought to be applied. That seems to me the right way to solve these, to set up the de-doctrinalized structure. I do think that Justice Breyer's work in criticizing the doctrinal approach and offering the proportionality alternative or reviving it from an earlier incarnation as balancing seems to me an extremely important contribution to our understanding of how First Amendment doctrine ought to be structured for the future.
Thank you. Maybe I'll say one thing that you will understand, you'll see, because it's a little detailed. But the Valor case was a very, very tough case for me. And I'm still not sure. You know, normally that doesn't work that way. Normally the farther I get from the case, the more certain I am I'm right. All right? But that's not that case there. And it was in a way hung by my own petard. Now why? Because I think that the proportionality, which encapsulates, I think, all these other things, works pretty well. Okay. Now here we have a case, somebody's lying. You see, he says, I have the Medal of Honor. And he didn't. He's lying. Okay, and that I would say by itself, as I said in the opinion, that's a legitimate purpose. And Congress could say this Medal of Honor is being watered down, and that's a good reason for limiting this lying statement. Okay, fine. But I have to go into the part about, are there less restrictive ways? And when I get into that part, I see that this statute is not just about the Medal of Honor, it's about any decoration, including sharpshooter first class, including all kinds of things that really nobody cares about, including Congress, and all kinds of situations. The guy is in the bar, and he says to someone he met, hey, you know, I have sharpshooter first class. And actually, Congress didn't care about that. And so it gives a lot of power to the prosecutor. And therefore, which is what I said. All right, and so I think, gee, actually, by the time you get finished with this, couldn't Congress write this in a narrower way? If they're worried about the Medal of Honor, write about the Medal of Honor. And this seems too broad. And then I feel uneasy about that, because I know, do you understand how? Yeah. I mean, if you're going to apply this balancing type of thing, you've got to do it, and then you're going to get into some tough situations where you know perfectly well that the, let's say, Scalia criticism has some weight. Aren't you putting your subjective ideas into this? And wouldn't it be better to have more direct rules? And then I say, no, it wouldn't. All right, then I've got to have the strength of my conviction. And that's those are those cases.
Well, actually, I wrote about the violent video case, and I'm just going to say just two things about it before we turn to Cass Sunstein. And I'm just going to quote from Justice Breyer's just superb dissent. California tried to forbid the sale of truly violent video games to minors. And Justice Breyer writes a dissent in which he says, a gruesomely violent video game of a kind that the industry itself tells us it wants to keep out of the hands of those under the age of 17. Why can't the state restrict the sale when the industry itself labels it? And then he ends the opinion, I think, with an equally wonderful question. What sense does it make to forbid selling to a 13-year-old boy a magazine with an image of a nude woman while protecting a sale to that 13-year-old of an interactive video game in which he actively but virtually binds and gags the woman, then tortures and kills her? What kind of First Amendment would permit the government to protect children by restricting sales of that extremely violent video game only when the woman, bound, gagged, tortured, and killed, is also topless? That's Justice Breyer. We turn now to Cass Sunstein, Professor Sunstein.
Okay, great. We have some amazing literature professors in the room, so in deference to them, let's notice that judges have 4 personas. So there are heroes. Earl Warren is the canonical or iconic hero. But I don't mean this phrase to be necessarily one of praise. So if you hate Earl Warren, don't dislike the talk quite yet. The Lochner opinion was a heroic opinion. The Lochner era was certainly heroic, and the Citizens United opinion is heroic in the sense in which I understand it. That is, it is a bold understanding of our constitutional structure that calls for invalidation of state or federal action. So that's the heroic persona, and there are literary analogs. Then there's the soldier who believes in following orders. The great Oliver Wendell Holmes said, if the people want to go to hell, I'll help them. It's my job. And soldiers see their role as one of deference to others. Then there are the Burkeans, great followers of Edmund Burke, who believe that abstract theories are not so good, and we ought not to be caught up in ideas. We ought to build incrementally and humbly on the past. And of course, they won't like heroes at all, and they won't much like soldiers either, who they think are in the grip of a theory. And then there are people who appear rarely but importantly, and they are the mutes, who believe that it's important not to say anything. And you can see the mutes just last term in the California case involving same-sex marriage, where the majority said nothing. And Alexander Bickel, the great law professor, was actually a theorist of muteness who thought that it had a prominent place. So that's background. I want to talk a little bit about the soldier and the role of the soldier. So that's the persona I want to emphasize. We've had some discussion of what for some of you may seem like a technical concept, which is Chevron. And the idea, for those of you who don't have it fixed in the mind, is that in the face of ambiguity, courts uphold reasonable agency interpretations of law. So it is in some sense emphatically the province of the administrative department to say what the law is, according to the critics. Justice Scalia is the principal defender on the court of Chevron, and Justice Breyer is the principal actual critic of a rule-ish reading of Chevron. Here's some data for you, though. This is a though. Justice Scalia has upheld agency action involving interpretations of law 52% of the time across a large swath of cases. 52% of the time validator. Justice Breyer, 80% of the time validator. Striking difference, yes? You might think that what's driving that is that Justice Scalia is a plain meaning guy and Justice Breyer is a purposivist, and so that's what's Justice Scalia is wielding the plain meaning against the administrative state, as Justice Breyer is maybe more reluctant to. But there's a data point here that creates a puzzle for this, which is that Justice Scalia shows an 18% increase in validation rights when the administration is run by a Republican president. A huge split between deference rates with the Republican and Democratic administrations. Justice Breyer shows no statistically significant difference between a Republican and Democratic administration. Essentially, for statistical purposes, zero. That's soldiering in action. That's following rather than heroism. Okay, I want to press on one little point that has to do with soldiering as I think Justice Breyer understands it, and that is something in his approach to law in general, which has 3 moving parts: active liberty, purposivism, and consequentialism. And he referred to the roots in Hart and Sachs legal process materials. Certainly purposivism, there's no reason you all should know this, but trust me, purposivism is the deep analytic heart of Hart and Sachs. What Justice Breyer has done that goes beyond that, I think, at least it builds on something that's at most implicit, is to put active liberty in the sense of self-government as the animating value, and to put a test in the forefront, which is consequentialism. Neither of those really quite in Hart and Sachs. I want to suggest about that is that for that to work, we have to have some empirical assumptions about institutional capacities, which I believe to be true, but which the jury's still out on, and which in an imaginable world are not true. And the question is whether the imaginable world is our own. I want to say a little bit about the relationship among the three concepts. It's not the case that if we have active liberty, meaning self-government, as our animating norm, that purposivism necessarily is the value that we follow. Take, for example, a law that bans discrimination, and the question is whether it bans affirmative action too. Or take a law that bans sex discrimination, and the question is whether it bans height and weight requirements as a form of sex discrimination. We can't read off from the text a purpose that will resolve the question, how to handle those two cases, can we? That is, as Gertrude Stein said about Oakland, there's no there, in the sense that there's no thing called purpose, which we can identify and then can work like an engine to deal with the hard cases, just isn't there, which is why Hart and Sachs and Justice Breyer, too, emphasize a reasonable person rather than just a fact, a person. And when we're talking about reasonable person, there's a degree of construction in it necessarily. There's an attribution to the purpose person. There's an attribution of purpose rather than a matter of finding something. And there's a bit of difficulty, isn't there? It might be that textualism at least has a claim. If it works, the textual has a claim that it creates, from the standpoint of active liberty, both good ex-ante incentives on the legislature to speak plainly and for active liberty to do its work, and a good incentive for an ex post corrective for the legislature, which will be stuck with its text and will have to fix it. Now, I think Justice Breyer will say there, textualism is Oakland too. There's no there with respect to word discrimination. What are you going to do with height and weight requirements or affirmative action? And that may well be so, which may lead us, if we're textualists for active liberty grounds, it may lead us not to purposivism, but to certain canons of construction that would say, in the face of doubt, everything gets upheld, the private sector can do whatever it wants, or in the face of doubt, remedial statutes are going to be interpreted liberally, something like that. It may lead us to an explicit rule-ish, at least, doubt resolver. Okay, all I want to say about this is that if we are committed to active liberty, we might, on certain assumptions about institutional capacities, choose textualism, or strong Chevron, or second-order soldiering of the home sort. Don't invalidate anything. Let it all get upheld, unless it's unambiguously a constitutional violation. And even originalism might fall out of active liberty. I think Justice Scalia thinks something like that. Now, in my view, in the end, Justice Breyer is correct, but it depends on some empirical assumptions which it would be nice to isolate about the capacities of the relevant institutions. If, for example, there were a parallel world in which the judges got completely confused when they tried to figure out what statutes meant, and which the administrative state was highly reliable in its law interpreting capacity, then strong Chevron of the rule-bound sort would look terrific. If we lived in a world in which judicial capacities with respect to purpose building on the constitutional side was a fraud and a deceit, then something like second-order soldiering of the validate everything sort would start to look pretty good. So that's to say that there are assumptions about institutional error, decision costs and error costs that are driving, I think, the conclusions. Now, the note on which I want to end is it is an irony of history, really, Supreme Court history, that the court's most powerful deference critic, who's in the room, is also the court's most persistent deference practitioner, which raises a question, I think, which is whether soldiering might be a form of heroism, too.
Wonderful. Justice Breyer, do you want to respond? And then I'm going to turn to Charles Fried and see if he has comments in general.
Or then I'll say, I have one general thing, but I have one specific thing for Cass. That's right. I mean, what I thought, really, speaking to Cass, is in active liberty, what I'm doing is connecting Hart and Sachs to the Constitution. And they didn't do that, and okay, so that makes, for whatever. But there's an empirical proposition there. And the empirical proposition is that if the courts in general will try to assume a reasonable legislature and interpret things that way, it becomes easier for the public to hold legislators responsible for what happens. And when they don't, then the legislator, it becomes messy, and you don't know what's going to happen, and the public generally, who can only know are things working out well or badly or whatever it is, will have a harder time. Now, that's an empirical proposition. And part of it, in England, for example, they wouldn't think of looking at legislative history. Why? Because they have a set of rules as to how you interpret things, which is well understood or understandings. But there will be another empirical test. Because in the EU, we are finding courts more and more looking at other countries' laws. Now, one thing they can't do, one thing they cannot do is know what the general assumptions are between legislatures and judges and so forth. In Estonia, maybe there aren't even any, but they're going to have to, but they can figure out human purposes. And so I suspect that will carry the day. But I can't prove it. Okay? So that's sort of interesting, I think, in that. And we'll have an experiment there.
Well, a number of the speakers, I think almost a majority of the speakers have noted the generosity and the lack of sarcasm in Justice Breyer's judicial work. Now, that disposition, which is a disposition of character and personality, is intimately related to the philosophical predispositions that we've been talking about, because it has been, I think, shown, and I think has been shown by philosophers at whose feet Justice Breyer sat. I'm thinking of Willard Van Orman Quine, who was a purposivist of whom Hart and Sachs may never have heard, but maybe they did. That to understand not only a constitution or a statute or a contract, but language, ordinary human communication, assumes generosity. It assumes that the person who is speaking wishes to make sense. And that is the only premise on which people can communicate with each other. Now, you take that deepest philosophical assumption and then apply it to legal texts. Why would you not apply it to legal texts? Why would you apply it to the texts which are the conversations we have with each other? Why would you apply it to literary texts? Why would you apply it indeed to biblical texts, but not to the Constitution, and not to statutes, and indeed not to legal texts in general? It is a way of making not just democracy work, but human interaction work, that we do our very best to assume that people are doing their best, and that when we listen to what they say or read what they say, we try to make the best we can out of what has been said. If that's what we do in conversation, why would we not do it in law?
Okay, can I say one general thing, well, two or three. One general thing is this, that it's interesting what cases you've chosen to discuss. And what really they've chosen to discuss are the cases where they think they can make something out of it. You see, that's their job. It has some seed. No, but it's an important job. There's some seed, or there's some way of looking at it, whether it's right or wrong, where they can turn it into something. which might bear some fruit, whether it's criticism or whether it's agreement or whatever it is. So that is now the two cases that I felt most strongly about, where my heart was really in it, parents involved. Say, where I wrote a dissent on affirmative action. Or Bush v. Gore. But that's me as a person. You say, I felt very strongly. Okay, feel strongly, go write it down. And be careful what you say. See, Judge Wisdom told me that. He says, when you really feel passionate, write down all that purple prose, and then read it, and then throw it in the wastebasket, and start over again, okay? And that's my second point, which I think is an important point, and it tells you, look, I'm not this angel that they depict, but I learned this from Al Sachs. I mean, you want to really criticize someone? Spend the time to write what's going on at a level that a child of 2 will understand it. And you say, what? What? You know, I mean, that isn't exactly being nice to the other person. And Al Sachs used to say, he'd repeat the argument that the other person had made that he disagreed with. He said, I understand it perfectly, except the therefore. Where is the therefore? And he did used to say that. All right, so, but the main thing that I want to say personally is thank you very much for this. I mean, my goodness. I mean, again, the younger students here don't know, but I mean, the most precious thing they have to give is their time. And there is nothing more. There is nothing more. And they spent time thinking about it. And of course, Harvard, you know, I went to Harvard Law School. I taught at Harvard Law School. So, I mean, Harvard Law School, part of it, I never complimentary, because I feel complimentary. And it would be complimenting something of which I am part. But Ken Galbraith explained it when he came back from India. He said it was fabulous. He met his friend of his in the yard in the economics department, and the friend said, Ken, yes, back from India, yes, I'd like to hear about it. He said, but not now. All right, so they've taken the time, they've gone through it carefully, and that is something I can say I appreciate it, but the fact is I do appreciate it, and I thank you very, 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 very much.
Well, I could say come back next week and we'll have the other 5 cases discussed, but maybe instead, just for a minute, should we ask or maybe do people want to ask questions, or we should move to the informal and anyone want to come up and ask questions more informally? How many people want to stay in session? How many people want to go informal? No one's voting. No one's voting. I think we'll go informal. That's what we're going to do. Thank you.